All right, this is case number 13-11-4301. This is Michigan First Credit Union versus Jeffrey Zuma. The matter is before the court. Looks like on a petition for installment payments. Let's see, I think there is your appearance at this time for Michigan First.
Your Honor, Michael T. Merritt, PA 1102 on behalf of plaintiff.
All right, thank you, Counsel, and good morning to you. Jeffrey Zuma. Mr. Zuma?
Yes.
All right, who are you? Are you? I'm looking for Jeffrey, last name Zuma, that's Nzoma. Are you on the Zoom?
Yes.
What's your name?
Tanya Jeffrey.
All right, so, all right, why do I have Zuma, Jeffrey, or whatever it is? What's the difference in the name? Go ahead, talk to me.
My first name is Tanya. Last name is Jeffrey.
Your Honor, I don't believe she is my defendant.
Yeah, that's not.
No.
You don't live on Cedarhurst, do you?
Oh, I'm sorry. No, I don't.
All right. When I call your name, that means I'm coming to you.
Oh, I thought you said Jeff.
Not a problem. Yeah, this person's name is Jeffrey, last name is Zuma. All right.
Oh,
All
okay.
right. Counsel, looks like the defendant did not appear regarding this petition for installment payments. I did, well, actually, it looks like that's already been entered. So what's going on here? Update me if you will.
Your Honor, this was a review for the motion for installment payments that was scheduled to August 22nd. It was adjourned to today's date. All it was a simple creditor's exam, but we don't label it as that. I believe the court calls it a review, just to see if we'd be able to increase the payment amount every month.
Got it. All right. Thank you, counsel. And I do see the notation now where I put that in. All right. So how is the payment situation going? The defendant's been paying?
Yes, I believe so. Your Honor, he's been paying by credit card every month. And if you give me one moment, I can let you know if he's made all 7 payments. Yes, since the date of the order, it looks like he's made all 7 payments.
All right. Well, I regret that she's not here. What do you wish to report? What are your thoughts regarding this matter, counsel?
Well, Your Honor, this is the first time I've had a defendant fail to show up in this court, so I don't know what the court's usual method of rectifying the situation is. However, if the court would be open to either increasing the amount of the payment nominally from 100 to 125 a month, and or issuing a bench warrant, but I would feel the bench warrant at this time would be a fairly extreme measure.
Yeah, I think so as well. Here's what I'm going to do. I'm going to continue it for 90 days, and I'll take another look. If the defendant does not appear at that 90-day review, we're going to set a specific date in just a moment. Then the court will be inclined to increase the amount in the defendant's absence to maybe 150 a month. I want to hear from her to see whether or not there's been any material change in circumstances. So I'm taking under advisement the request to increase the amount, and I'm setting it over for review 90 days. That date's going to be
December 15th.
December 15th at 9:45 a.m. Notice will be generated to all parties, of course, including the defendant. So,
All right. Thank you very much, Your Honor.
thank you, counsel. Good day to you, sir.
You as well. Have a great day.
The court now calls case number 22-178017. This is National Collegiate Student Loan versus Tanya Jeffrey. The matter is before the court selling for a hearing on today's date. The record should reflect that the complaint that was filed in this matter sounding in a student loan scenario alleges damages in this matter in the total amount $5,599.78. All right, I did receive a written statement from the defendant in this matter, that she disagrees with the amount of the summons, and that there was a total of $4,100 paid to Asset Recovery Solutions. Counsel, your appearance for National Collegiate.
Yes, thank you, Honor. This is Natasha Dixon on behalf of the plaintiff. My P number is 82333.
All right, thank you, counsel. Good morning to you. I'm looking now for Mrs. Tanya Jeffrey. Say something at this time, ma'am.
Yes, can you repeat
All right.
that?
Good morning to you, ma'am.
Good morning.
All right,
Judge.
so this looks like the first hearing regarding this matter, and it doesn't appear that there is a dispute, that there is an indebtedness, but it does appear that there is a dispute regarding the amount of the indebtedness. Defendant indicates that she paid a substantial amount to Asset Recovery. Counsel, and I am looking at a diary which suggests payments of $205 per instance. On that form that has two non-sufficient fund notations. Counsel, what do you know about this, Madam Counsel?
Yes, Your Honor. I did speak to Ms. Jeffrey, and I try to make kind of explain what's going on, taking a look at the documents. So what happened, Your Honor? She did make payments, but they were in the amount of 3280, and actually the document she has attached show that as well, toward the settlement. I mean, and what happened was, since no further payments were made on the settlement to Asset Recovery, so the settlement amount was $4,884. Since no further payments were made, the settlement arrangement was broken, and then so that's why they're pursuing the full balance. And I did go over the payment history with her, but unfortunately, there's no resolution at this point.
All right, so that the agreement was that if she continued on the plan, that she could pay it off at one amount, but if she broke that agreement, then it would go back to the original amount. Is that correct?
Yes, Your Honor, the settlement arrangement was broken due to no further payments received. And they did, Asset Recovery did, contact her, to see if she can resume it, but there was no response, so they had to break the agreement.
All right. So is there some room to for the parties to get this resolved? I guess I'd like to know what's the difference between what would be owed if she was still on the program versus what's owed now that she is did not keep the agreement.
The difference between the two amounts would be $1,604. And Judge, we are open to settlement. The plaintiff is open to settlement, and I did, speak to Ms. Jeffrey over the phone some time ago, and I made some settlement offers. And during the breakout room, I did say, I can make you another offer, working with their situation, but unfortunately, I don't know if she's interested in a settlement. We'll be happy to work with her, but.
All right, thank you, ma'am. All right, Ms. Jeffrey, so you had an agreement where you were to stay on plan and that this would be paid off, is that correct?
Correct, of $4,000.
You didn't keep
That's
the plan.
what I assumed the plan was, to pay a total of $4,000. And I assumed I paid $4,100. The initial loan was for $5,000. Over the years, I done paid over $7,000. $458.
Yeah, you know why that would be the case. That you know why you would have paid more, because of interest, right?
Yes.
All right. So counsel, I guess the defendant is saying that the overall, at the time that the agreement was started, what was the principal balance at that time, counsel? Do you know?
Yes, the balance at that time, it was $8,879.78. And the settlement agreement was based on that balance.
All right. And so it looks like, Ms. Jeffrey, that a part of it, the agreement on the settlement is that if you did not keep the terms of the settlement, that it would go back to the original balance. And meaning that you would get credit for the payments that you made, but that you would have to deal with the full amount as opposed to a compromised amount. That's what this looks like anyway. So it seems to me now that in order to resolve this, that the parties would have to find some accommodation point to do that. If this case advances to a trial, then basically what happens is that the court would take into consideration, as I must, the payments that are made. It looks like taking that into consideration would be based upon the accrued amount at the time that the agreement was entered, minus any payments that are made and minus any interest, or in addition, adding any interest that may have accrued over that period. So what you have is you have a situation where you have a $8,000 debt at the time that you entered the agreement. Interest is still accruing on that, but you're making payments that will give you the right to offset all of that. But then when you didn't keep the payment arrangement, it went back to the original amount. And so now to move forward, you got to find a way to see if you can get a compromise on the remaining indebtedness. All right, so you talked about it. You can't find a way to bridge the difference.
Well, I just wanted to say that I didn't feel like I did not hold the settlement amount. I assumed it was 4,000. And I assumed I paid 4,100. And so at that time, no, I was not available to take the calls because I was not working and I was taking care of an elderly parent. So I assumed it was settled. I did. But then it came back saying that I'm being sued for the whole amount.
Right.
And the settlement amount, I don't mind agreeing on a settlement amount, but I'm on a low income and it's no way I can pay the 1,000 and something a month.
Yeah, I'm sure of that, ma'am. All right. So was there some discussion about an amount and what would be paid on a monthly basis? Obviously, the defendant seems to do pretty well on making payments that seem to amount to, looking now. Just one moment. Saw that. Yeah, $205 a month is what she was paying, and she seemed to do pretty well with those payments, although she had a couple of NSF, but most, I would say, better than 90% of the payments did in fact clear. If you came up with an amount and you were able to continue to pay the $205, would you be able to do that at this time?
Well, that's more reasonable than the two payments of 1,000 and something dollars. There's no way I can do that. 200 in the amount that I was paying, yes, that would be something I can do.
Well, I don't know what the settlement offer is, and I don't want to get into that too deeply, but it sounds like what you're saying to me is that the settlement offer says that if you make two lump sum payments of X amount, that would close the case out, right?
Right.
Okay.
Right.
So,
correct.
Might as well tell me now. So what was that? The two lump sum payments of $1,000 or $1,500?
It was something like that was offered. With the things that was the amounts that was offered to me to pay, it was out of my level for payment.
You told me that six times already. That's why I'm trying to find a solution. But you already told me it's out of your pay raise. I got that part. The years got that covered. All right. So why don't you see if there, I don't know, is there some more room to talk on this? Obviously, it sounds like Ms. Jeffrey is not able to completely cash it out, but it also sounds like this has a long tail on it. It's been going on a long time, and maybe if you lock the amount and then set it over a period of time with a balloon at the end, maybe that's an easier way of doing it. And basically what I'm thinking about is that you stick in the $200 payments over a period based upon a settlement, with a lump sum due at maybe $1,000 at some point in the future. That's kind of what I've got in mind. I'm going to send you all back to breakout just to see if you can find any traction to get this done. So Ms. David, I'm going to move you to 2 just to make it a little bit easier. Ms. Jeffries, I'm sending you to breakout number 2. Let's see if we can get some traction on this. All right. All right. And I'll stand down and I'll wait your turn on this, man.
Thank you.
So go ahead and click in, Ms. Jeffries.
Oh, thank you.
Thank you. Ladies and gentlemen, thank you for your patience. I'm calling case number 22-185480. This is New Grace Spinal Rehabilitation Center versus City of Detroit. The matter is before the court. Looks like set for a first hearing. I do have the City of Detroit's responsive pleading regarding this matter. Your appearance for New Grace at this time.
Morning, Your Honor. Fadi Toma on behalf of the plaintiff, New Grace Spinal.
All right, go ahead and give me your P number, Mr. Tolman. Good morning to you, sir.
Sure, 63746.
All right, thank you, counsel. For the City of Detroit, counsel, your appearance at this time, please.
Good morning, Your Honor. Mary Beth Cobbs for the City of Detroit, P40080.
All right, thank you, Ms. Cobbs, and good morning to you as well, ma'am. All right, as I indicated, it looks like this is first time up on this. I don't know if the parties have gotten any traction on this moving forward yet, or obviously at this point, I would treat it as something of a scheduling conference to begin to move this in the direction of some discovery, et cetera. Your thoughts, Ms. Cobbs, please.
Yes, Your Honor. We would ask that this be put on track. That the city does intend, after some discovery, to file a motion for summary disposition.
Thank you, Madam Counsel. Mr. Toma, any thoughts in this regard?
No, Your Honor, no objections to that. I think discovery period would be fair for both of us.
All right, very well. So the court will formally open discovery regarding this matter, and I'll allow that period of discovery to be open through a period just beyond 60 days. The specific date on that discovery will close is also the date of the pretrial conference. That date's going to be
11/22.
11/22/22, and that's going to be at 9:45 a.m. 11/22/22, 9:45 a.m. Discovery will conclude on that date, and that will be the date of the pretrial conference. I also will allow on the date of the pretrial conference for the parties to have motions heard if you wish to do so. This does not preclude filing motions on a schedule that might be offered in the future, but it gives you opportunity at this point that if you have something that you believe you want to bring before the court for hearing on the 22nd, all you need to do is file the motion, set it for hearing on that date, and the the main requirement is that you give at least 10 days to the opposing party to respond to the motion. So if you have a dispositive motion and or non-dispositive motion, you can set it for hearing on 11/22/22, and I will hear it on that date, so long as you've given the opposing party at least 10 days to respond to your motion. That will be included in my scheduling order under paragraph number 6. Paragraph number 6 will give you the same information I've just given to you. The pretrial scheduling order will also have the next action date, which you know is 11/22/22. That will be in the order, as well as the discovery cutoff and other information. So I'll get that out to you today. I look forward to seeing you on 11/22/22 at 9:45 a.m. Good day to both.
Thank you, Your Honor.
Thank you so much, Your Honor.
Thank you.
Take care.
Bye-bye.
The court now calls case number 22-187700. This is Credit Acceptance Corporation versus Tammy Hayes. The matter is before the court on the filing of a general civil complaint arising out of a loan in association with a automobile and a claim breach of contract in that regard. The claim for damages herein is in the amount of $5,862.73. I have received the defendant's answer to the complaint in this matter. Just one moment. I one of the things she raises in her answer is that the car was sold, that she thought the car was sold and that the debt was resolved in that way. All right, your appearance for the plaintiff credit acceptance, please.
Good morning, Your Honor. Lynn Olivier, appearing on behalf of plaintiff.
Thank you, Ms. Olivier. Good morning to you. Let's get your P number for the record, if you will.
39006.
Thank you, Madam Counsel. And again, good morning. I'm looking for Tanya Hayes, Tammy Hayes, I'm sorry. Ms.
Yes,
Hayes,
I'm-
Tammy Hayes.
Yes, I'm here, Your Honor, this morning. Good morning.
Good morning to you, Ms. Hayes, and thank you for being here.
Thank
So this is the first area status conference, really a time that the courts typically set up a schedule regarding this matter. But at times, parties are able to talk about ways of getting these matters resolved. Sounds like to me that this was an automobile that was repossessed and sold or something at auction, and that this is a suit for a deficiency balance. Is that about the size of Ms. Olivier?
Yes, that is correct. And Your Honor, I didn't realize my defendant was had appeared. We have not had an opportunity to speak. So if you'd like to put us in a breakout room at this time, plaintiff would be in favor of that.
Yeah, I
Yes.
think that, Ms. Hayes, I think that that's a really good starting place, and you might be able to get things worked out. Let's talk about the differences and see if something can be worked out. So I'm going to send a notification to both parties to go into a breakout room, and then you'll be able to return thereafter. And there is your notification, Ms. Hayes, and Madam Counsel, Ms. Olivier, I'm sending your notification as soon as I can be smart enough to find you. Disappear. Oh, there we go. All right.
Thank you.
All right, so just click into the breakout room, Ms. Hayes, and you'll be able to speak with the attorney to talk about whether or not you might be able to get this resolved. All right, and Mr. Morris, why are you here, sir?
Good morning, Your Honor. Sam Morris, on behalf of Evokes, in the matter number 2218445, Evokes v. Miss Grimes. I think we had initially been set on for today. I had filed a
I gave him one.
Yeah, I think that's what he's been pointing out. So you'd asked that it be adjourned, and then it was our mind that we would set it over for the 26th. But let's go on the record and let's see where it is at this time. I do see that it appears that Ms. Grimes is here as well. This is case number 22184845. This is Evokes IOM versus Maya Grimes. The matter is before the court, set on for a hearing. Looks like this may be the second hearing regarding this matter. All right, counsel, your appearance for the record, sir.
Good morning, Your Honor. Sam Morris of Burr Foreman on behalf of the plaintiff. My P number is P76766.
Thank you, counsel. And Ms. Grimes, it looks like you're here. Say your name for the record, ma'am.
My name is Mia Grimes.
All right, thank you, Ms. Grimes, and good morning to you.
Good
as
morning,
well.
Your Honor.
So I received a request to adjourn the status conference, but that's not a problem. The parties are here, so let's see what's going on regarding this case. Counsel, go ahead and talk to me, sir.
Certainly, Your Honor. And I believe this is the first setting since the pleadings were filed. Your Honor, this is a simple breach of contract case. My client, Evokes, is a neurodiagnostics provider. When it hired Ms. Grimes, the parties entered into a contract. My client invested significant time and resources to enable Ms. Grimes to obtain certification as an interoperative neuromonitorist. As part of that agreement, my client required a certain amount of time of employment following that investment. The employment contract states that if Ms. Grimes were to voluntarily terminate her employment after a year, but before 2 years, then the parties agreed that the amount of compensation to my client would be $10,000. Ms. Grimes left voluntarily left the employment of Evokes shortly after a year's worth of employment. And so my client has filed suit seeking the agreed amount of damages that was provided for in the employment contract.
All right, and was there any, at the time that Ms. Grimes left, was there any release assigned by the agency that would release her from the conditions of the agreement?
I am not aware of such, Your Honor.
All right, so Ms. Grimes, you were employed and trained by Evokes, is that correct?
Yes, I was employed and trained by them. I'm no longer using the training or employment due to COVID. Everything has changed, which I was unaware that I would even be able to use the certification, which has changed my income. I'm no longer benefiting from any of the training. I no longer have a status of a monitorist because I am not vaccinated. So all of the contracts should be null and void. I'm no longer able to use it. If I was making the income that I gained from Evokes, I would have no problem, but I am making less income than when I started training there. So I no longer have certification. I'm no longer allowed to use my monitorist state board-certified certification due to COVID. So again, the language that they use, I basically assumed that if I was continuing to use any of the training or any of the degrees that I earned from them, I would be liable, but I'm no longer liable. I can't even work that much. I'm working a totally different job, earning maybe a fourth of the income that I earned from the training I received from them.
All right, so your understanding of the contract in this matter is that if you do not use the training, that the contract is void. Is that what you understood?
Yes, Your Honor.
Did you also understand about the contract that they had, that there was a what's generally referred to as like a liquidated damage provision that says that if you leave prior to the expiration of the agreement, that you would be obligated for $10,000. You understood the contract to say that, ma'am?
I understood the contract as if I benefited from the training. If I was using that training or using that certification, that I would be liable, but I'm no longer using any of that training. I'm not allowed to use it.
Right,
So
yeah,
I'm earning no benefit from it.
Let me stop you for a moment. You told me all that before, but I asked you a question that was more specific than that. That does not
Okay.
take away what you just told me. More specifically, my question directly to you is that you understand that the contract had a liquidated damage provision or provision that says that if you leave before the expiration of 2 years, that they would hold you liable for $10,000. Did you read that in the contract?
I read that. I must have misunderstood that if I left with that training, I would be liable.
Didn't ask you all of that, but you read that in the contract, correct?
I did read that. Yes.
Okay, and what your understanding is then that based upon other provisions in the contract, your understanding is that that $10,000 requirement would be waived if you were not benefiting from the training after you left. That's what you're telling me, right?
That's correct, Your Honor.
All right, thank you. Counsel, what about that, sir?
Your Honor, I do not have the contract in front of me. I do not believe that there is some sort of exculpatory clause from the damages provision that would allow one of the employees to not be required to hold up that end of the contract if they were to cease using their licensure. But I can certainly check on that and run it to ground, but I do not believe I saw any sort of carve out that Ms. Grimes has described.
All right, I do By virtue of the attachment of the contract to the complaint, I do see the relevant provision under minimum service period, paragraph number 9, section B, triple I, provides $10,000. There's a descending contractual provisions based upon whether or not a person exited the service and the employment voluntarily. And the lower descent under the 3 I's is $10,000, and I quote $10,000 if the relationship voluntarily terminates or is terminated by the company with cause after 1 year anniversary of the date I successfully complete the CNIN R.EPT or R.EEGT, but before the second anniversary of such date. So it is quite an extensive contract across 7 pages. Just one moment. Just one moment on this, David, I'll be right with you.
Your Honor, the only carve out that I see from the provision would have been a failure to pass the licensure exam. I do not see the carve out that Ms. Grimes has described.
Well, there's a carve out for failure to complete the program and carve out for failure to complete the licensure. So it would be real technical about it, Joe. Yeah, I'll start finding all kind of little minutiae of carve outs, but what I am not seeing, and admittedly, I have not gone through it. And then there's another way that this has to be dealt with by summary disposition perhaps. But I wanted to kind of give the parties an advance and address if there was something specific in the contract that gave a carve out, because the specific language regarding the exit, the voluntary exit, and whether a year was completed, those seem to be factual predicates that are not in dispute. The question is whether or not there's a carve out, whether or not there is an exception within the 4 corners of the contract that allows or that vitiates or eliminates that provision. And that's what I'm looking for on the surface to see if there's something that it does that. And so far I have not seen it, but give me just a few more moments. And I'm not saying that I'll be able to use my expert skills in 5 or 10 minutes to look at this, but if there's something that jumps out, then I'll tell the parties. So just one moment. my surface, maybe perhaps a bit more than a surface review of the contract, does not lend itself to language that would carve out an exception for that provision where the defendant is no longer, number one, working for the company, number two, working in the field, number three, using the license or advancing her initial interest in pursuing the career choice that came. So the fact that you don't use it or that you opted out, there's not anything in the contract that provides a way to escape the contractual agreement to pay or repay what is in contractual language a liquidated damage clause of $10,000. Now, having said that, I mean, that's what it looks like. If somebody can, Ms. Grimes or anyone can put together a document that shows and demonstrates that there's something in the contract that avoids the provision that the plaintiff is suing under, then obviously that would be something of critical implications in this case. The other thing that I wanted the parties to think about a bit is that while there is nothing contractually that provides relief in this regard, it seems to me that one of the things that Ms. Grimes is saying is that a part of the direction of her choice was associated with a global pandemic. There's nothing in the contract that allows for that allows a provision where the tenant, where the defendant could escape the contract by virtue of some extraordinary conditions such as a global pandemic. That does, however, seems to be the kind of scenario in which talking about ways of resolving it, compromising on the obligations set in the contract is probably a reasonable thing to do under those circumstances. Of course, I can't force anybody's hand on that, but the contract is pretty solid. But you know, there was by some estimations, there is still an ongoing global pandemic, and Ms. Grimes says that her actions were secondary to the to not wanting to be involved in this particular field associated with the global pandemic issue. That does not avoid the contract. That is a basis for the parties to talk and say, how do we come together on this? And if you can't, then the next step, I think, would be to file a motion for the court to decide this on the basis of some disposition. All right, so what I'd like to do is I'm going to go ahead and, well, I'll set a date when you come back in. I want you to take a moment and break out in light of what the court has talked about as what seems to be the direction of this case, and see if there's some room to talk. You don't have to fall out of fight, of course, but see if there's some room to talk about resolving this. If there's not, then I'll set a date for cutoff of discovery and for motion hearing, and the parties go forward that way. All right, so I've sent you directions for a breakout room. I'm going to stand down. When you're done, just come back in and we'll find out which direction we'll take regarding this matter. All right, thank you, Mr. Grimes. Thank you, Counsel.
One quick technical question. I see there's the invitation to join the breakout room. When we join the breakout room, will there be a similar link to return to the forum?
I believe so. It's supposedly is intuitive. So go ahead. And if for some reason it gets crazy, then just hang up and dial back in. Okay.
Okay. Thank you, Your Honor.
Right. Thank you, Counsel. All right. Thank you, Ms. Gibbon. And you were dealing with the case involving Ms. Hayes. Is that correct?
Yes, Your Honor. Yes.
All right. So we're back on the record regarding 7700. And it looks like Ms. Hayes is back as well. And Counsel, go ahead and update me if you will.
Your Honor, that's my case. Jimmy Hayes.
I am okay. So I'm dealing with credit acceptance versus Hayes. So that's Ms. Olivier, correct?
Correct.
I'll with you in just a moment, ma'am, and Ms. Jeffrey. All right, so thank you, Council. Regarding this matter, Ms. Olivier, update me if you will.
Your Honor, we have had an opportunity to discuss this matter. We have reached an agreement. The parties agreed to the entry of a consent judgment for plaintiff and against defendant for the full amount as paid for in plaintiff's complaint, that being damages of $5,862.73, costs of $129.08, statutory attorney fee of $75. The plaintiff has given the defendant a credit of $1,120.20. So the total judgment amount will be $4,946.61. The parties agree that the defendant shall pay the judgment in installments of $180 each month, beginning October 21st, 2022, until the judgment is paid in full, and the plaintiff shall not issue a periodic garnishment as long as payment is made. I've indicated to the defendant that we will be both emailing and mailing the proposed consent judgment to her for signature for her to sign and return to us so that we can then submit it to the court for entry.
All right, what was your total again? 4,000?
Yep, 4,946.61.
All right, and Ms. Hayes, is this in fact the agreement that you entered into, ma'am?
Yes, sir. Yes, Judge.
All right, you heard the numbers that were set forth, $4,946.61 with an agreement to pay at $180 monthly commencing on October 21st, 22 until paid in full, and no garnishment of the non-periodic. Which one was it that there was no agreement to not garnish?
The plaintiff shall not issue a periodic garnishment as long as payment is made, so our wages are protected.
Yeah, so your wages would be protected. That was the one I was getting at, for sure.
Yes, definitely. I like to hear that my wages won't be touched. Jesus, Lord.
Right, I wanted to drill down on that one just so that it's clear as to what was being said here. So these are the terms, ma'am. You agree to that, ma'am?
Yes, Judge.
Now, counsel pointed out to me that she was going to email it to you, then you get it back, and then they send it to the court. If the terms that are set forth on this record are on that document, is it all right if the attorney initial that or sign your name by consent, and I will then sign off on it? If it doesn't, if for some reason it doesn't have the terms that we agreed to, then I'm not going to sign it. If you receive it from me, from anyone that has any terms on there that you didn't agree to, all you need to do come on the Zoom any day. You say, Judge, I got that judgment and it says 5,000 instead of 4,000 something. It says 6,000, whatever. In other words, there's no trick to this. You understand?
Yes, sir.
All right. Any problem with her signing off on this and by consent on the record regarding the terms as set forth on this record?
Not at all. I appreciate that, Judge.
So what I'm going to do is, Ms. Olivier, I'm going to give you the email address where you can send that. You can email that to the court and just put by consent on the record. And again, Ms. Hayes, if there's any problem whatsoever, just notify the court and come into my and the case number, and then I'll get a hold of Ms. Olivier and we'll have a hearing on it and figure out what's going on. But the ideal here is that the document is going to say exactly what you agreed to. Okay.
Yes, sir. Yes, Judge. Thank you.
Thank you. So Ms. Olivier, the email address is Latifa, LATIFAH, Hunter, HUNTER, at 3636th District Court.
LATIFHA, I'm sorry, FAH.Hunter, HUNTER, at 3636th.
Yeah, there's another device that's been interrupted. So you look at what you have and let me just go through it again. That's Latifa, LATIFAH.Hunter, HUNTER, at 36districtcourt.org.
.org.
Yeah.
Okay, will do.
All right, all right. Good day to you. Good day to you, ma'am, Ms. Hayes, and all the best to you in regard to getting this resolved.
Yes, thank you, Judge. Thank you, Miss Olivia, as well. Thank you.
I tried to give you another case, I guess, Madam Counselor. Are you on the National Collegiate case?
Yes,
All right.
yes, Judge.
All right, so we're back on the record at 8017. I know the parties took a moment to talk about this. Go ahead and update me, Madam Counselor.
Yes, Your Honor, thank you. I did speak to Ms. Jeffrey and we have reached a resolution as far as the settlement. I'll be mailing her a conditional dismissal with the terms. And, you know, once she signs it, she can send it back. We'll send it to the court.
All right, and that makes sense to you, Ms. Jeffrey? You found a way forward?
Yes, sir. Yes, Judge.
All right. So a document's going to be sent to you. It's got something to do with ultimately the case being dismissed. And so once that's signed off on, then that document will be sent to me, and that should resolve things. Right? All right. So I wish you well, Ms. Jeffrey. Thank you, counsel, and I await your order.
All right.
Thank you, Judge.
All right, Mr. Ocker, what are you doing on here, sir?
Good morning, Your Honor. May it please the court, Jared Hocker. I'm appearing on P71123. I'm appearing on the case of Midland Funding versus Wilda Nance.
One second.
That's not right. What's the case number?
What's your case number? Because we don't have that up. Go ahead, sir.
Sure, the case number 22178222. I'm sorry, 21-199019.
You said 21.
Yes, -199019.
That's not coming up.
Yeah, let's try one more time. 21 dash
19
19
90
19.
19.
No.
No, we're not getting anything on that. And you have that here at 36 District Court?
Yes, Your Honor. It was a case where in front of this court, I was appearing on behalf of Michael Supton. The case was previously before the court, looks like on August 17th,
Yeah,
2020.
Let me get some other information.
The defendant's last name?
What's the defendant's last name?
Sure, Nance, Nance is her last name.
First name is
Wilda, Wilda.
be right with you, Mr. Morris and Ms. Grimes.
On his case number is
Thank you, Your Honor.
22-178-222 for Midland.
What's the number?
He said
21?
for Midland.
Yeah,
Yes, Midland Credit Management versus Wilda Nance.
Okay, hold on 1 second. I'm because that case number you have is not a correct case number. So let me give you what the case number is. 21
22
22
178
178
222
huh?
222. Triple two is
Okay,
222.
so 21 222
Uh-huh.
178.
Yep.
Okay,
178
21
222. Yeah.
21 222 178 is the case number that correlates to this case. And the case name is
Is dismissed for Wilder Nance for Midland funding. The plaintiff sent in a dismissal on 9/8.
yeah, plaintiff sent in a dismissal on 9/8 on this case.
Right, Your Honor. I just wanted to verify that the court dismissed the case with prejudice.
Yes.
I don't know if it's dismissed with prejudice
It
or
is.
not. Yeah, it is a dismissal with prejudice, counsel.
Thank you very much, Judge. You and your family have a great day. Thank you,
All right,
Madam Court Reporter.
Thank you, sir. Okay, so we're back on the record regarding Evokes versus Grimes. And I want to thank the parties in advance for taking an opportunity to go into the breakout room. Council, you may proceed to give me an update if you will.
Thank you, Your Honor. This is Sam Morris on behalf of the Rooks. Your Honor, the defendant and I had a civil and thoughtful conversation, but I would like to report that I think we are at very opposite, almost polar opposite ends of the spectrum. We did exchange contact information, and I invited Ms. Grimes to reach out as the summary disposition process proceeds, and that we would be, we're always willing to listen if there is, of course, a proposal. However, at this time, we have not made much traction. I think we'd like to go ahead and get some dates on the calendar to advance the case.
Got it. All right, that's about the size of Ms. Grimes. You're not able to come to any resolve at this time. Is that correct, ma'am?
That's correct, Your Honor.
All right. All right. So what I'm going to do is I'm going to set this case on a roughly a 60-day calendar, and I will open discovery. That allows for either party or both parties to request information mutually in writing, and whatever information is requested under the court rules, the parties are required to turn over such information to the other side. If you receive something in the nature of interrogatories or requests to admit and other type documents that are called discovery documents, you're required to answer those documents within the time prescribed within the document, typically within 28 days. If there's something in the nature of a request to admit, if that document is not answered, then the request to admit is deemed to be admitted, meaning that you won't be able at a future date to change the fact that you've admitted something, even if you didn't answer it. So you'll be required to answer within the time prescribed by law, whether that's going to be a denial or admission. You have to respond to it. Does not respond to it means that you have responded. If the parties choose to, they can also set up a deposition, something that requires an appearance with a court reporter to take down testimony under oath. So those things can take place over the next 60 days. The date for the cutoff for discovery in this matter is going to be.
You said 60 days?
Yeah, or just be 60 days.
Or just be 11/23.
11/23.
Mm.
All right, that's going to be 11/23/22 is when you're coming back to see me. That's going to be at 9:30 a.m. On that date, I will also hear any motions that you might wish to bring before the court. A motion is a document requesting the court to do something. That motion can be dispositive, which means that what is being requested is to somehow bring the case to finality, or it could be non-dispositive, which means to address some issue within the case that does not finally address the alternate issues in the matter. If that motion is filed with the court and set for hearing on the 23rd of November, I will hear the motion as long as the person opposing the motion has at least 10 days to respond. So if you file a motion, as long as the other side has 10 days to respond to the motion before the hearing, I will hear the motion on that date. There are court rules that allow for the filing of motions and have certain requirements of dates and times. But the court is, by its order, setting times and dates for the filing of motions. Now, the 23rd, motions can be heard on that date if you file them under the scenario that I've given, give the other party at least 10 days notice for the hearing. On the date of the 23rd, if there are no motions on that date, but the party still wish to file a motion, I will at that time set a schedule for the hearing of motions that have not been filed. But this is just an avenue to allow you to bring something before the court that is right, that you wish to be heard on, that the issues are already before the court, and so there's no need to delay. So set it for hearing on the 23rd, give the other side 10 days notice, and I will hear the motion at that time. That's going to be under paragraph 6 under my scheduling order. I will be sending a scheduling order out to you in the mail. It will have It will have the date of the next hearing as I've given it to you, as well as other information. Paragraph 6 will tell you about the right to file motions and having heard on that same thing. All right.
Your
That's
Honor,
all I'm gonna- President.
Your Honor, I have two brief questions. One, would it be possible to have the next hearing on the 22nd and not the 23rd of November, just with the 23rd being the day before Thanksgiving and not wanting to draw the ire of my mother-in-law with a hearing on what I anticipate being a travel date?
The 22nd, we'll go ahead and move it to the 22nd. So 11/22/22 at 9:30 a.m. That's when you come and see.
Thank you, Your Honor. And then my second question is anticipating filing a motion for summary disposition to be heard on that date. Will the court allow the hearing to be a summary disposition hearing to be by Zoom, or do I need to appear in person?
No, the hearing will be by Zoom.
By Zoom, thank you.
The only requirement on the motion for summary disposition is to give Ms. Grimes at least 10 days prior to the hearing to respond to the motion.
Okay, thank you, Your Honor. And then the last question is that a docket call at 9:30, or is that a special setting on the 22nd?
It's a docket call at 9:30.
Okay.
But we usually move through rather quickly. We're pretty efficient about getting right at what the issue is. I don't kick around too much. So if you're here, you're going to be heard right around that time. Okay.
Thank you, Your Honor. I appreciate the court's leave to move to the 22nd. You'll save me significant heartburn.
Not a problem, sir. All right. And thank you very much. Thank you, Ms. Grimes. I'll see you at the next action date, the date.
Thank you.
Thank you.